purse is Satchel Paige, who is famous for many things, including telling you to avoid eating fried food. And so thank you so much for helping us with the lunch along those lines to the people at the Levin Center. But one of the other things that Satchel Paige says is, let whomsoever sit around recollecting, I'm looking up the line. I think that's a perfect name for this panel, which is going to consider redistricting, partisanship, and the future of the Voting Rights Act. But I want to start a little bit with the past of the Voting Rights Act, because I think it situates many of the debates today. The year that the Voting Rights Act was passed, Langston Hughes published a poem called Longview Negro. And the poem goes like this: sighted through the telescope of dreams, emancipation loomed very large. And then Hughes writes, but turn the telescope around, look through the larger end, and wonder why what was so large becomes so small again. We are now roughly a half-century away from the second Reconstruction, of which the Voting Rights Act was the crown jewel. In many ways, the Voting Rights Act has been amazingly successful, and so we forget what prompted the Voting Rights Act to be passed in the future. But when we ask why the first Reconstruction, which was roughly twice as far from the Voting Rights Act as we are from the Voting Rights Act, in the opposite direction, that is, it was 100 years from the first Reconstruction to the Voting Rights Act. It's now been 50 years, roughly, from the Voting Rights Act to today. When we ask why the first Reconstruction failed, there were a number of reasons for that. One was the exhaustion of the national commitment to racial justice and its replacement by cynical bipartisan compromise in which the ins kept themselves in and kept the outs out. A second was a progressive belief, and that progressives used the word to describe themselves, but a progressive belief that ethnic politics is the enemy of good governance, and that purging race from the political process is important. Yet a third reason was the United States Supreme Court, which in a series of decisions from United States against Cruikshank to Giles against Harris, gutted the protections of the first Reconstruction and gutted the ability of minority communities to protect themselves through the political process. Now, President Johnson, when he signed the Voting Rights Act, called it one of the most monumental laws in the entire history of American freedom, and then in his colorful Johnson way went on to call it the goddamn toughest Voting Rights Act that his staff could devise. But he also famously remarked, after signing the other crown jewel of the second Reconstruction, the Civil Rights Act of 1964, that I think we just delivered the South to the Republican Party for a long time to come. So partisanship and the Voting Rights Act have always been connected and intertwined in interesting and important ways. Our panel today is going to look at those issues from a variety of perspectives. And I'll introduce the panelists very briefly in the order they're going to speak. Ellen Katz is a professor of law at the University of Michigan Law School, where she writes and teaches about election law, civil rights and remedies, and equal protection. She's written major scholarship, both doctrinal scholarship and empirical scholarship, including one of the largest studies of Section 2 of the Voting Rights Act, and has a contribution to the symposium here at the Stanford Law and Policy Review called Democrats at DOJ, Why Partisan Use of the Voting Rights Act Might Not Be So Bad After All. Before entering teaching, Professor Katz worked at the Department of Justice. Joshua Thompson is a staff attorney with the National Litigation Center at the Pacific Legal Foundation, a prominent conservative public interest legal organization. Of the most salience to our topic today, he was co-author of the Pacific Legal Foundation's amicus brief to the Supreme Court in Northwest Austin Municipal Utility District No. 1 against Holder, a case challenging the constitutionality of Section 5 of the Voting Rights Act, an issue that we know is about to return to the Supreme Court in a variety of ways. Finally, Nina Corrales is Vice President of Litigation for MALDEF, the Mexican-American Legal Defense and Education Fund, and in that role, among other things, she supervises MALDEF's offices throughout the United States in their voting rights dockets. She is a particularly prominent voting rights attorney. Most recently, she was the last winner of a Section 2 case at the U.S. Supreme Court for the plaintiff's side in Lulac against Perry, a case we discussed quite a bit this morning. And she is one of the lead lawyers in the current Texas redistricting case that is working its way through the Western District of Texas, through the District of Columbia, and the Supreme Court. So it's a kind of trifecta. The panelists are each going to speak for about 10 to 15 minutes, and then we'll turn to questions about changes in the world since the Voting Rights Act, what those changes portend in thinking about how the Act gets applied, and indeed whether the Act survives into the future. So, Ellen.
Thank you. It's great to be here. It's been a great day so far. I want to thank Alex and Slipper. I didn't know that was what it was called, but for organizing really a terrific event. I know Nina's going to talk about the Texas case in detail, but I want to start there with a simple observation, and that is that much of the mess that's been going on in Texas would not have happened if John McCain was president of the United States, and that a Republican, by which I mean a Republican-controlled Department of Justice, would have almost certainly approved the Texas plans by now, almost certainly as is. It wouldn't have stopped the litigation. There would still be much to fight about, but in that respect, at least, some of the mess would not have happened. And as it stands, Greg Abbott, the Attorney General of Texas, never even asked the Department of Justice to approve the Texas plan, opting instead to go to federal district court, thinking that Barack Obama's Justice Department would not view the Texas redistricting plans kindly or favorably, given the partisan implications and the civil rights objections that had been raised from the beginning, and that prediction was correct in that the Justice Department has raised a number of quite serious objections to the plan. In, I think, important respects, the Texas dispute provides a mirror image to one of the major redistricting battles of the last decade, only with the Republican and Democratic roles reversed. And I'm referring to Georgia versus Ashcroft, which Pam spoke about this morning. And there you saw a Democratic Attorney General thinking that the Justice Department, that George Bush's Justice Department would not look kindly on a democratically gerrymandered plan, and going to district court, and George Bush's Department of Justice did indeed raise objections in court. I don't want to explore the statutory questions that were at issue in that case. I think one of the things that is clear about the case is that the Department of Justice's position in that case mapped onto the strategic interests of the Republican Party. And just as certain, had there been Democrats in control at the time, a Democratic DOJ would have approved that plan readily. And what I think both of these cases standing side by side show is something that we all know, and that is that Democrats and Republicans enforce voting rights quite differently. Democrats tend to enforce them in ways that devolve to the benefit of the Democratic Party, and Republicans do likewise. And very often this corresponds to Democrats reading the Voting Rights Act more expansively and more aggressively, but not always, and I think Georgia versus Ashcroft is perhaps the best example to the contrary. And what I want to explore here is the question whether we should be worried about this. Whether the different ways Democrats and Republicans enforce the Voting Rights Act prevents the statute from operating effectively or as we hope it would. And in thinking about this question, I want to assume, or I'm going to assume, that the party of the sitting president stands to benefit from the enforcement actions taken by the Department of Justice. I want to be agnostic and ask you to be agnostic as well as to whether that actually describes any particular enforcement decision. So I'm not, I want to assume that that's what's going on, and I don't want to make the argument that in fact Democrats or Republicans are necessarily seeking partisan gain when they make any particular decision, but what if they were? So imagine, for instance, that Assistant Attorney General Tom Perez were to say something to the effect of, the Department of Justice's position in the pending Texas versus the United States is an effort to block an aggressive Republican gerrymander, and we're using the Voting Rights Act as a convenient legal hook to push back against it. Now, he, of course, never said any such thing. He said quite the opposite. But assume he said it, and assume it accurately described what the Department of Justice was up to in this case. Should we be worried? And what I want to suggest or explore is the idea is that maybe not. maybe we should not be worried, and maybe it is not a particular problem, at least in cases like Texas versus the United States. And in pursuing this claim, we're going to have to part company with many commentators, some who are sitting in this room, who have long viewed partisan use of the Voting Rights Act as distasteful and even destructive. And one of the things I'm going to explore, or press upon, or push, if you will, is the notion not just that partisan use of the Voting Rights Act in cases like Texas versus the United States is benign, but rather that the practice actually helps enforce or helps the act or facilitates the act in important ways. So to do that, or to develop those claims, I want to do two things. First, I want to briefly look at two objections to partisan use of the Voting Rights Act, and hopefully knock them down, and then raise a broader point about the practice more generally. So two objections, there are others, but two objections to the practice. One is that the claims that are brought forth when the statute is used for partisan purposes are frivolous, or factually unsubstantiated, manufactured to serve distinct ends. The idea here is that the claims underlying, that the disputes underlying the claims are partisan in their nature, they're not racial, and that those unhappy with districting plans suffer as members of a political party, not as members of a racial group, and to assert a racial claim under the Voting Rights Act is factual error. I think related to that is a second objection that it's not just error, it's not just factually wrong, but it actually does affirmative damage, that the recasting of a partisan dispute in racial terms racializes the dispute and gives rise to harms that the statute itself was meant to address, things like racial polarization. It makes things worse as a consequence. And in a nutshell, what I want to say about both those claims is I think they fundamentally mistake cause and effect. California aside, redistricting is a partisan process, and almost always is a partisan process. But it's achieved or it's done through what are race-based moves in most jurisdictions. That relies on the close connection between race and party in most jurisdictions. It's not an accident that Georgia Democrats in Georgia versus Ashcroft unpacked African-American districts to achieve the ends of their partisan gerrymander. It's not an accident in Texas that Republicans are achieving partisan ends by moving Latino voters all around the state or all around the districts that they draw. We shouldn't be surprised that these partisan moves yield race-based injuries. To put it differently, the Voting Rights Act claims that follow from these cases don't racialize a non-racial dispute. These disputes are racial from the get-go. They're political too, and all I want to suggest about them is that partisan motivation, even predominant partisan motivation, shouldn't immunize or somehow preclude statutory injury under the Voting Rights Act. The claims we can assume are manufactured to achieve partisan ends, but it doesn't mean that the claims themselves are frivolous or otherwise factually unfounded. And I think we could go through case after case, and I won't do it now, and actually see in a lot of these cases where we might think partisan motivation is playing a role, very substantial claims under the Voting Rights Act have been raised, even if they're not always successful. So I want to suggest that partisan motivation, at least in certain kinds of cases, like Texas versus the United States, assuming that's what's going on, is not the problem I think it's often assumed to be. It effectively provides pushback against partisan districting moves that themselves rely on the close connection between race and party. But I want to also suggest or ask you to consider a broader point about partisan use of the Voting Rights Act, and that it might be beneficial in an additional sense, in that it helps us see the ways in which the mission underlying the Voting Rights Act has in fact evolved and expanded over the years. This is a statute, and we've heard about this today repeatedly, that was put into place at a time when local majorities were unwilling to even acknowledge, much less enforce and protect minority voting rights. And it continues to serve, I think, very important functions in fighting invidious discrimination in various forms. But it also does something else. It provides a forum to resolve disputes. It is a dispute resolution mechanism, by which I mean it sets forth a complex web of substantive norms and procedures through which interested parties hash out and resolve competing claims about minority participation in a majoritarian system. And I think that function of the Voting Rights Act is crucially important. there are other ways we could assess questions of equality and fairness in the political process. And I think the value of the Voting Rights Act as a dispute resolution mechanism lies not simply in its, not in its manifest superiority to other forms of dispute resolution, or even in its historic salience, which I think is actually quite significant. Rather, I think its value lies in the fact that it operates as a tolerable form of dispute resolution, and I really do mean tolerable. I might be more generous and say that it's fair and effective and just in many situations, but for the point I want to make, I think tolerable is actually good enough, because tolerable captures the role it plays. It's tolerable, it exists, and simply because it exists, state and local governments can rely on it, and that reliance is to them empowering, and this is the point I hope I can convince you of. By empowering, I mean something different than the ways in which the Voting Rights Act has been recognized to give the beleaguered local official political cover to do the right thing against a majority that might not be so willing. I'm mindful of the VRA's role there. I think it's an important role. But I think the VRA is empowering in a much broader sense, in a sense to all local officials, be they sympathetic or not to the goals underlying the statute. And what I mean here is, or relies, I suppose, on a larger literature that recognizes the way power can be augmented through its selective restriction, and that the VRA is in fact empowering by the very constraints that it imposes. It offers a system to resolve competing questions about equality. So think about the Texas dispute here. Texas needs to redraw its districts. The Republicans are in control of the process. Democrats want to push back. Republicans are trying to get as many seats as possible. And very quickly, the question becomes, how many seats will Latino voters control? How many seats, how much influence will they be given or allowed under, in the midst of this fight? But that fight occurs and continues now, not as a question of what is fair or in an open-ended inquiry about what equality might require, but instead in a much more limited and circumscribed inquiry about what the voting rights requires. That question is disputed hotly, and we're not going to see a resolution to it for a while, I suspect. But the VRA's role is not eliminating the controversy, but giving the language, the terms, the norms, and the procedures through which that claim is going to be litigated and resolved. When Texas puts forward its plan, it has to say it complies with the Voting Rights Act. And that's going to be opposed and is being opposed, and Texas needs to respond. And that conversation continues. And we can assume that everybody's motivated by partisan aims. Counterfactually, if you will. We can assume that that's what's going on, and still, the Voting Rights Act, I think, is performing an important function, a vital function, in framing the debate and providing procedures and rules through which that debate occurs. It's a way of hashing out the competing claims of equality while still channeling it and keeping it circumscribed. I think it allows the participants to assert less ownership over the claims that they're making, and that this effectively, for all the heat that's been generated, lessens the heat that might otherwise exist when these issues are debated. And I think it's important to recognize the VRA's role as a dispute resolution mechanism, because it enables governance. I think we think about the statute too frequently in negative terms, as a constraint, as binding us to the mast, if you will, to prevent us from doing things we might otherwise do. I think it has an affirmative quality that is important to recognize. Not simply because it gives us a more complete picture of what the statute does, but I think it also gives us or makes us aware of what would be lost in its absence. One of the reasons I think the Voting Rights Act actually is so vulnerable today is because it is too often conceived of too narrowly. There's tons of debate. I've participated in it. Many people in this room have participated in it about how effective it is as a constraint, and whether or not it's still needed in those ways. And what I want to suggest or close with is the thought that it's more than a constraint. It does more than constrain local power. Even if the VRA, and I'll again say counterfactually, has somehow evolved or developed into that elephant whistle shooing away a non-existent threat, even if that were true, it's still performing what I think is a critical function in helping localities assess and resolve divisive issues that are recurring and unavoidable, issues like how much influence Latino voters should have in Texas, These are questions that are not amenable to a permanent solution. They're going to come up again and again. And the reason is not that racist intent necessarily underlies the resolution, although it may well be underlying its resolution. But because the discrimination that gave rise to the Voting Rights Act in the first place, and our longstanding efforts to address it, have shaped the political landscape in enduring ways. And the result is that all public officials, be they of goodwill or not, need to confront these complex issues. And I think the Voting Rights Act provides critical assistance in helping them through this in ways that are actually not just constraining, but frankly, empowering. And I have more to say, but I'll say my closing thought. I think this assistance should do more than bolster the regime's validity. I think it actually provides an independent basis for it. Why don't I stop there?
Thank you. I'm Joshua Thompson. As noted here, I'm from the Pacific Foundation. I want to thank Slipper and Alex for inviting me here. I'm a last-minute replacement for Abigail Thernstrom, who shares something in common with my fellow panelists, in that she's probably forgotten more about the Voting Rights Act than I will ever know. But nevertheless, I'm going to try to develop a thesis that I think she would support, and that is that Section 5 of the Voting Rights Act is unconstitutional, and that the court will find it unconstitutional. My thesis is not that the Section 5 of the Voting Rights Act must be or was always unconstitutional. It's that it is, as currently constituted, unconstitutional. So Section 5 was passed pursuant to the 15th Amendment's remedial powers and requires covered states in the South to achieve preclearance as originally understood. Because it's passed pursuant to Congress's remedial powers, it must be congruent and proportional, though that standard may be disputed a little bit and was definitely disputed in Northwest Austin. The latest Shelby County case certainly agreed that it must be congruent and proportional, and it must be, so in other words, Section 5 must be a congruent and proportional remedy to achieving enfranchisement for minorities. And when Section 5 was passed in 1965, we were 100 years after the 15th Amendment. We were in an extreme state of discrimination, disenfranchisement of African Americans in the South. Justice Thomas in Northwest Austin recalled the story of a North Carolina mayoral candidate who urged white voters to shoot in their tracks any African American they saw voting. At that time, Mississippi had 7% African American registration rate. Alabama was 19%, while white voting in these states was well over 50% higher. How did these states achieve rampant disenfranchisement of blacks? Well, at that time, it was primarily done through literacy tests and poll taxes, which Section 5, or the Voting Rights Act, basically outlawed. But more importantly, it was a continuous effort by the South over 100 years to change and amend their voting practices to disenfranchise African Americans. These literacy tests, for example, would ask things as ridiculous. The examples are how many bubbles are in a soap bar, or they would ask African Americans to read the content of the Beijing Daily, which of course is in Mandarin. So this is the state of affairs in 1965 when Section 5 is proposed as a remedy to gain 15th Amendment rights. It was seen at that time as an extreme temporary remedy. It was initially passed for 5 years. Justice Warren, Chief Justice Warren, when the Section 5 was first up for constitutionality, called it an uncommon exercise of congressional power that would not have been appropriate absent the exceptional conditions and unique circumstances present in the targeted jurisdictions. In dissent, Hugo Black described Section 5 by providing that some of the states cannot pass state laws or adopt state constitutional amendments without first being compelled to beg federal authorities to approve their policies. So distorts our constitutional structure of government as to render any distinction drawn in the Constitution between state and federal power almost meaningless. One of the basic premises upon which our structure of government was founded was that the federal government possessed certain specific and limited powers and no others, and all other powers to be reserved to the states respectively or to the people. So despite the rampant intentional discrimination going on at the time Section 5 was adopted, the Supreme Court, the President, and the Justice Department all recognized its temporary need, but recognized that it was an extreme remedy that only justified by the times it was passed. And I argued that it was a congruent and proportional response to discrimination in voting in 1965. Section 5 of the Voting Rights Act was constitutional, it was passed, and remained constitutional for some time after that. And sometimes good legislation produces good results, which Section 5 undoubtedly did. Near immediately after Section 5 was adopted, Mississippi, which, as I previously said, in 1964 had 7% black registration, jumped to 60% within 3 years. Alabama went to 52%. But more importantly, the situation continued to improve over the years that Section 5 was in force. To the state now where the covered jurisdictions in the South, their state legislatures are 31 to 45% African American. A previous one-party system of Dixiecrats has evolved into a two-party system. But the reasons why besides the times changing, the reasons why I want to argue that it's unconstitutional today are twofold. One, that the covered jurisdictions cannot be distinguished from the uncovered jurisdictions in terms of discrimination presently occurring. And secondly, that the Section 5 does not address modern voting problems. So the jurisdictions, the jurisdictions that are currently covered are not currently the jurisdictions that generally experience the most egregious voting rights allegations. In 2000, there was the main allegations of discrimination were coming from Florida. In 2004, the main allegations of discrimination were coming from Ohio, neither of which are covered jurisdictions. Registration, turnout, and office rates in covered versus non-covered jurisdictions are almost indistinguishable. They are within single-digit percentage points. Preclearance denials, I know one of us doesn't think that is a valid basis on which to judge the discrimination occurring. Preclearance denials by the Justice Department have dropped from 4% to 0.2% despite the increase in requests for preclearance. Findings of intentional discrimination by the federal courts since 1982, there have been 24 findings of intentional discriminations in voting. 11 of those have come from covered jurisdictions, meaning 13 of those have come from uncovered jurisdictions. And more Section 2 cases are brought in uncovered states than are in covered states. Secondly, it does not remedy modern voting wrongs, and I think this was exemplified better than I can do by our speaker from the Brennan Law Center, that current complaints of discrimination are basically across the country. They are not generally found, they are found in the covered states, but they are not exclusively found in the covered states. We've heard Wisconsin mentioned, my home state Wisconsin mentioned a number of times, Rhode Island, Minnesota, New Hampshire, and New Hampshire's partially covered, but the claims of discrimination nowadays are registration problems, voter identification problems, provisional ballots, precinct maladministration, errors in tabulation, reliance on old technology, poor ballot design. These things, not only are they not different in covered versus non-covered jurisdictions, but they are at times exacerbated by Section 5's preclearance formula. Because if a particular polling place has long voting lines, if a particular polling place has outdated tabulation machines, it behooves these jurisdictions not to seek preclearance. It behooves them to keep the current status quo in place. It will not have to amend those problems, and this exacerbates the problems that are most often cited as cases of discrimination in voting. But there are a lot of other problems with Section 5 that both the Supreme Court and scholars have talked about, including the coverage formula, which has been in place since 1972, how it differentiates between states despite our constitutional framework of equal sovereignty between the states. It's been argued that it causes cognizable harm to minority politics, and the list can go on. So I believe that Section 5 is unconstitutional. It will be obviously coming before the Supreme Court, most likely next year. All of the justices have signed on to at least some of the complaints that I've laid forth, and I expect it to be ruled unconstitutional.
I have a PowerPoint, but I have no object.
You're about to get one. Ask and ye shall receive.
Thank you. Hello, everybody. Take a deep breath. Deep breath. This is a really good panel because I don't agree with anybody on it. We are co-counsel. And first of all, I want to say thank you very much for bringing me here. And I want to also, I want to thank the university, the law school, whatever the slipper is. I want to thank Alex. And I want to thank Pam especially because as my co-counsel, she has done the heavy laboring on a number of briefs that we've done in the Supreme Court during this time. Now, how do you go forwards? The right button. The right button goes forward. Okay, partisanship? Not so much. I don't agree. Let's talk about Texas redistricting. Here's my positions. Republican versus Democrat, outmoded thinking. This is not a reflection of reality in Texas redistricting, and I think it's going to become as vestigial everywhere else as it is in Texas. I think where the real issue is and where people need to be paying attention is on Latino population growth, Latino political mobilization, and the challenges that that poses to incumbents of both political parties and operatives, leadership of both political parties. So let's start with some context. This is Latino population growth between 2000 and 2010. It's very similar to Latino population growth from 1990 to 2000. The red bar are the Latinos. Green is African American, yellow is other not Hispanic, and the smallest growth is white alone not Hispanic, which we call Anglos in Texas. If you combine both decades, over which, by the way, we haven't gained a single congressional seat, Latinos have grown by 5.1 million in Texas, Anglos have grown by 1.1 million in Texas. So let's just start from there. These are some of the South Texas districts that are currently Latino majority. This was one of the exhibits that I showed during the trial. You will see from the west, El Paso, 16, overpopulated by 58,000 in the benchmark. Big West Texas, 23, the love of my life, and the subject of litigation in Lulac versus Perry, overpopulated by almost 150,000. Congressional District 20, San Antonio, Charlie Gonzalez, over by 13,000. 28, Henry Cuellar out of Laredo, 153,000. CD 15, Hidalgo County, Ruben Hinojosa, 88,000. Corpus Christi to Brownsville, Texas, the lovable CD 27, overpopulated by 43,000. If you add up the overpopulation of these existing Latino majority districts, you get 3/4 of an additional Latino majority district. So this presented, of course, an enormous challenge to Texas redistrictors who really didn't want to increase the number of Latino opportunity districts, right? So here's the 7th district and the one that we proposed, which runs from San Antonio to Southeast Austin. This was an idea that the leadership thought was a good idea, and they incorporated a version of it in their congressional map that the state passed. This was vigorously opposed by the Democratic leadership, because it in fact goes in and gets Latinos out of the district of a current Anglo congressional incumbent. Alex, where'd you go? What's his name, Alex? Tell it loud.
Lloyd Doggett?
Yes, sir. Lloyd Doggett.
The 35th.
And the new district is the 35th. Lloyd Doggett was not included in this district, but was planning to move in and run, and did not want to run in a Latino majority district where he was going to face a strong primary challenger from the Latino community. Let's talk about Dallas-Fort Worth, where Latinos have grown quite a bit, and where the Anglo population of Dallas County alone dropped by over 200,000 in the decade. Here you have a lot of Latino population that runs east-west, which is why you see the state's enacted plan carving districts north and south. So you see districts scooping from the south, and then you see districts scooping from the north. And the one that I want to point your attention to is District 26, which comes out of heavily suburban Anglo-Denton County, and has kind of what we call the lightning bolt down into the Latino areas of Tarrant County. Now you might say, well, this is really still about partisanship, isn't it? Because they want to try to break up Democrats, put them in Republican districts. But I want to show you how carefully this line carves through Tarrant County to pick up the red areas, which are Latino citizen voting age majority block groups, compared to green areas, which are African American citizen voting age majority block groups. The lightning bolt only gets Latinos and leaves African Americans in another district where their vote is diluted as well. So this is now, I know y'all care about Congress and that's what's sexy. Anybody here from Texas? Hello, where are you from in Texas?
College Station.
College Station, gotta love it. Okay, well we're gonna talk about Nueces County down in South Texas. This is the house map. You don't care about the house map, but I do. Look at the orange district in the middle. We call it Little Nemo. That House District 33 is 60.4% Hispanic citizen voting age population. It is next to another Hispanic citizen voting age majority district, HD 34. And it also shares portions of Hidalgo County with HD 32, which is an Anglo majority district. Keep your eye on Nemo. Oh, he's gone! Look what happened in the state's map. They shoved all the Latinos over into HD 34, as many of them as they could, and Nemo has been disappeared, broken up, and is no longer there. There he is, and now he's gone. And this was what was done in the state's enacted map. If anybody needs a definition of retrogression, that is retrogression. It's not hard at all. Here are the antlers in El Paso. 77 is a Latino majority district. 78 is a district that is just barely Latino majority, but represented by a state rep who's not the Latino candidate of choice. How do you protect a guy in 78 who's not the Latino candidate of choice in an 80% Latino county? You go with antlers and you get most of his Latino precincts, leaving behind a Latino Spanish surname registration minority district in a very heavily Latino county. And I gotta love these antlers. I had to do another one of just the antlers for you. These antlers do not line up with precincts. They split 14 precincts. They don't hug the mountain as originally tried by redistrictors in terms of an excuse, but they do line up very well with the highest concentrations of block groups of Hispanic citizen voting age population. Here's the failure to add a new Valley House seat. Top map is what the state enacted. Lots of seats down in the Rio Grande Valley, a very, very heavily Latino area and also very impoverished. There was enough overpopulation, again, the issue of overpopulation. There was enough overpopulation in the existing districts to create a whole new district right there inside two counties, Cameron and Hidalgo. And the state did not do it. We proposed, what you see is that sort of big purplish thing on the bottom map. And that was the additional district that Cameron and Hidalgo County had enough population for, but which was never drawn. What's at stake? That's in Cameron and Hidalgo County. That is in Cameron and Hidalgo County. That picture was taken by one of my lay witnesses who, in the DDC trial, unexpectedly began to weep on the stand when he told the story as a priest of having to give the last rites to a little boy who was burned in a fire and for whom the ambulance could not come because the streets were not paved. And that's what's at stake in the Rio Grande Valley. So when we're thinking about redistricting as maps and lines and colors and numbers, that's what it's about. That's the difference between having another seat in the valley and another voice in Austin compared to not. So the Threering Circus, what did you call it, the trifecta, Pam?
Yeah.
We challenged these Texas redistricting plans in Texas, in the Western District of Texas, in San Antonio. It's been a long road since July. Let's see, we went into a very compressed discovery period, lots of exchanging of things, lots of depositions. We tried the case on the first workday after Labor Day. We tried it into mid-September, and then we did post-trial briefs, and then we did some more briefing and another mini-trial. And then by that time, the state of Texas was underway with its lawsuit in the Washington, D.C. federal court, seeking preclearance from the courts. I have to disagree a little bit with Ellen here. I think if they had submitted the plans, the DOJ still would have objected, as DOJ objected to the House plan in 2001 under Bush II, because they did find retrogression. I may be overconfident in my case, but I think we would have gotten an objection at least on the House plan, if not the Senate. But in any event, Texas, in its wisdom, chose to go to court, filed an unsuccessful summary judgment motion. We just tried that case from January 17th until the day before yesterday. And then in the middle of all of that, we had Perry versus Pettis, which was the appeal of court-drawn interim maps. The big top on the circus is that we have to have elections. And we have, in fact, very early primary elections in Texas. Our elections are typically held March 6th, or the first week in March. The backed up deadlines, including under the new military voters and the MOVE Act and the precinct realignments and all of that, bring us into October 2011, which is why the district court in Texas, you might have been wondering, drew interim plans as early as it did in November, was because we have very early election deadlines. The political parties are putting a lot of pressure on the district court in San Antonio because they need to hold their political conventions in June. Prior to that, they need to select their delegates, and that's what they do in the primary elections. Besides nominating people to run on the ticket, they also select their delegates for the convention. So a lot of what was being done in November in Texas was about drawing maps to make sure we could try to stay on schedule somehow. We'll see if we do. There is now a new April 3rd primary date, which we may or may not be able to make. We're trying. So one of the things, and you've heard people talk about racially polarized voting, there's still a lot of racially polarized voting in Texas. And it's not just in the general election. You cannot slap a partisan label on what's going on here. What's more important to us in many ways is the racially polarized voting that goes on within party primaries. So, because of that, non-Latino Democratic incumbents are very concerned about losing the primary to a Latino challenger. So, for example, not just in the Congress plan, where we were proposing an additional district that was opposed by the Democratic leadership and the Democratic incumbent, the same thing happened in the House. We had we still do have an Anglo incumbent in a district that's about 47.5% Spanish surname voter registration. We proposed putting in a few more Latinos. There are no other Latino majority districts around there. We figured, let's just take these folks, they're outside, we'll put them inside, bump them up just over 50%. Who was the most aggressive opponent of that? The incumbent. There are also non-Latino and some Latino Republican incumbents who are concerned about the burgeoning Latino population within their districts, which translates into pressure to change some of their policy positions. If your district is 40% Latino, or 45% Latino, or 48% Latino, you cannot run around saying deport everybody. That's not going to work. So there's a pressure there to change the policy positions to seek out the support of your Latino constituents. So there's some reaction, and you'll see it in the Texas plan, of trying to draw districts that have some Latinos in them, but not enough to be able to change the outcome of the election for an incumbent who doesn't want to change policy positions in the general election, right? And so you see lots of different kinds of fracturing in the plans to meet those ends. So now that's why you can see, that's why I always say a pox on both houses with respect to Democrats and Republicans, right? So this is basically what I just told you. And the potential large amounts of flexibility that Latinos in Texas have with respect to partisanship. Because Texas is a fairly conservative state, and so are Latinos, and we haven't had exactly the same experience as California. And so, you know, there's a lot of mobility here, but people aren't completely sure how to respond. And what we're seeing right now, honestly, on the part of both political parties, is not to respond by reaching out, not to respond by being inclusive, both geographically or district-wise or position-wise, but to fracture, and preserve incumbents. What Latinos have done, we've been litigating a lot since July in just this state. We have formed together into coalitions to try to accomplish the litigation. And also there's a lot of awareness, I mean, don't be fooled, there's a lot of awareness on the part of Latinos that the VRA, the Voting Rights Act, is being invoked by both political parties to serve their own political ends. Why is the press still reporting this as Democrats versus Republicans? Because they're very, very confused and they're not really paying attention. They haven't seen or haven't recognized the increasing mobilization of the Latino community. They're very distracted by Democrats versus Republicans. Nobody's really paying attention to what's going on in court, so I read stuff that's completely not reflecting what's going on in court, both in the media and sometimes in the academy. And also you get a lot of drumbeat from the political operatives that this is really about Democrats getting screwed, or this is really about Republicans something else. And I don't think it's about any of that. And then, of course, at the end, that the VRA has outlived its utility, which I'm feeling right now, the VRA is very vibrant. It's really helping us in the litigation. So I'm not going to agree that it's outlived its utility, particularly because I think we have some very strong intent claims in this case. I'm looking to the future, because that's what it's about. I showed you some pictures of what it's about. Have you done? Stand up. That's what it's about. My son's 15 years old. He came with me today. He's going to vote soon. Not too soon. Not too soon. But we'll be voting. We vote after we die in Texas, but not before we're 18. He will be voting in this decade. And it's not just my own interest in casting an undiluted vote. It's the interest that my children will also cast an undiluted vote in Texas. So that's where we're going. I think there's going to be greater Latino participation in primaries, in general. I think that we are going to present a tremendous challenge with our population growth. I think both political parties are going to have to wise up, stop fracturing, start reaching out. What is the ideal for the Latino community? Have people from both political parties knocking on your door saying, I want your vote. I will do what it takes to get your vote. And hopefully that will cause the Latinoization of a little bit of both political party platforms. Thank you.
So I want to give the panelists the chance to respond to each other, and then we'll take some questions from the floor as well. So I don't know, maybe start in kind of reverse order. Nina, is there anything more you wanted to ask either Joshua or Ellen? And then Joshua will get a chance to Ellen.
I don't think I have any questions.
Okay. Joshua, do you have questions for either Nina or?
Same. I think I'll refrain from asking questions.
So I guess I'll ask Ellen if you have questions. I guess you all have answers. Questions to the answers.
I feel slightly like it's off. Like Nina was just such a force here that we would speak of. I just wanted to just back up with something that Joshua said. I think one of the difficulties in the Section 5 constitutionality question is this claim that is the claim that why don't the covered jurisdictions continue to go worse than the non-covered jurisdictions? There are problems elsewhere. It's under-inclusive. I think Pam made a powerful point this morning about that, about deterrent effects. I think the numbers are misleading because we're looking at a heavily regulated system and a non-regulated system. And I think one of the things that debate obscures is, well, I would be really concerned actually if the covered jurisdictions continue to have vastly more Section 2 cases with this regulatory regime in place that is shielding and blocking all sorts of stuff. So this point is out there. So I think in some ways, if it continued to look the way it looked in 1965, it would be crazy to be sticking with that system because it wouldn't do a very good job of accomplishing its purposes. And I think we agree on more than
Yeah, I would say two things to that. First, it was the situation in 1965 that authorized this. The court at that time recognized it as an extreme temporary remedy. Congress did, the President did, the Justice Department did. And I don't think anybody here is of the opinion that the state of the South is as it was in 1965. And same, I don't think anybody here would argue that discrimination is absent in the South in 2012. But, so, the first point would be that it isn't, the remedy that Section 5 is not justified by the current times, despite the existence of some discrimination. But more importantly, I think what the state of the South today, and that so many black elected officials are present in the South, is that the discrimination that would need to occur to disenfranchise blacks at the rate that we saw justifying Section 5 would have to be done by the black elected officials themselves. And it would have to be done on the backs of, with legal organizations like MALDEF and the NAACP and all these other organizations that are out there fighting for the rights of minorities on a daily basis. And I just don't see that the deterrence effect that being covered today is justified given the state of race relations in the South today.
The thing that has puzzled me for a long time is the sort of question of who should decide when Section 5's usefulness is outgrown? And what is it that makes Section 5 such an extreme remedy? As I understand, the argument that people who think Section 5 is an extreme remedy focus on is that the state can't put its plan into effect until it gets precleared. It's the kind of, as you put it, Jeff, the Hugo Black, they have to go with their hat in hand to Washington like a bunch of beggars. Is the problem that only a few states have been selected out for this, or is the problem that somehow federalism says that jurisdictions should be entitled to put into effect their plans and put the burden on voters who've been denied their right to vote to come forward? I've never figured out whether it's the burden of proof or it's the timing issue or that leads people to think Section 5 is an extraordinary remedy. I understand the Supreme Court said that, but I still am trying in some sense to figure out about the preclearance regime what's extraordinary. I understood what the Supreme Court thought was extraordinary in 1965 was that the federal government was chopping out literacy tests without any proof that there was anything wrong with a particular test. But I never understood how that got translated into Section 5 preclearance regime being extreme. And so I wonder if any of the panelists have any speculation as to why that seems to be the thing that the court's so focused on now. Because that really just goes to burden of proof and timing in most cases. That is, in most cases where there's an objection, presumably a plaintiff would be able to challenge, and in many of those cases, as Nina points out in the text, they would be able to challenge successfully. So what Section 5 has done is simply change the timing and burden of proof. It hasn't changed the ultimate outcome nearly as much as people who assume if we got rid of Section 5, it would seem to assume. So I'm just trying to figure out what is it about Section 5 that seems to drive Supreme Court justices into this kind of paroxysm of, federalism revival.
I mean, I think you just said it, but it's the reversal of the burden of proof and the notion that the presumption is that you're not doing something that we think you're bad until you show us otherwise. And I think one of the things that I would hope to pull out of this is the notion that there's actually value in that for the jurisdictions themselves, even if perhaps they are not convinced of it. That this regime, almost in a constitutional sense, provides a framework for which they don't have to take certain responsibility and go forward with the rest of lives.
I wanted to mention that I thought it was a very interesting dynamic in this most recent Supreme Court appeal that we just did, where at first, I had the sense that the Supreme Court was a little indignant that the Texas court had drawn interim plans that departed from the legislatively enacted plans, and especially because Texas was presenting this as a really dramatic departure from what had been enacted, even if that wasn't really true on the facts. But when we got to the day of argument, I sensed a very different dynamic among the justices, and it seemed that maybe by the time the briefing was done, they might have been realizing that there were some pretty serious things wrong with the Texas plans. And when Chief Justice Roberts said to the Texas request, put in the legislative plans, we'll just sort it all out later, that Chief Justice Roberts took the initiative to say, these plans are not pre-cleared. We need to get some kind of feedback here on preclearance. I had the sense that maybe there was an implicit recognition that the shifting of the burden of proof was important for exactly the reasons that we had in front of us that day.
Yeah, and this is a question I think comes out of Joshua's comments, maybe to you, Nina, which is Joshua's point is we would not design Section 5 the way it was designed if we were designing it today. And certainly I don't think anybody would design a system in which there will be parallel litigation in two federal district courts with the Supreme Court stepping in. And so if you were designing Section 5 today, what would, or you were trying to design a regime today to protect the interests of Latino voters, how would it differ from the regime that we have in place?
Well, I think the problem was that Texas took this thing off the rails when it filed litigation instead of in the administrative process, because that would have moved much faster. And since the DOJ isn't even taking a position in opposition to the Senate plan, the DOJ, Texas probably could have gotten the Senate plan pre-cleared right away. I think they would have had a much better sense of clarity on what may or may not have been objectionable in the other two plans. And not only did Texas decide to file litigation, which is very slow, they rejected the idea of going to trial in November, which would have given us a decision that would have avoided this kind of crash and burn that we had in December. But even though the district court in the District of Columbia was saying, you know, you could not file a summary judgment motion, you could go to trial in November, Texas said, no, we want to file a summary judgment motion, and that just bogged things down more and more and more and more. So I'm not sure if there's anything wrong with the structure as much as there was a series of really catastrophic decisions by the legal team representing Texas that caused this crisis. Some people suggest they wanted to cause the crisis so they could go to the Supreme Court and say, take our plans, please. But that didn't work either.
Right, but that seems to me to be the gamble they were making, and in fact the gamble in their brief, which is put our plan into effect even though it hasn't been pre-cleared.
Which in effect was saying declare the statute unconstitutional.
Without having to say it,
yeah.
Right, but that didn't work either. And so I know that there's a lot of publicity around the Supreme Court decision, oh, striking down Texas maps, bad, wrong. I was thrilled, because that was the decision that day that said Texas could not put its plans into effect. And frankly, in this war of attrition we've got going on, where we're in this court, we're in that court, and we're in that court, every day the Texas plans are not implemented is a day of victory for me.
It's like the Anita Bryant theory, every day the orange juice is a day that says.
Exactly. Sunshine today because we're not voting under the Texas plans.
I mean, this is one, I think this is also, though, one of, in some senses, the unintended consequences of the Voting Rights Act is, in its initial understanding, of course, Section 5 was intended, and Joshua makes this point a little bit, to freeze into effect the existing system so states couldn't make it worse. Because the history from 1865 to 1965 is, anytime you won a case in court, the state would come up with some new, wonderful, tricky way of changing it. So the Supreme Court struck down the grandfather clause, and Oklahoma announced you have 3 days to register, or else it goes back into effect, or the like. And as the Supreme Court recognizes in the Perry against Pettis case, you can't do that in redistricting. That is, the existing plan is rendered unconstitutional immediately when the census numbers drop. So you have to have some new plan put in a system in which you now have not just not the one-party system of the South in 1965, but essentially not even the two-party system. Your point, Nina, is we now have 3 competing interest systems in places like Texas. You're guaranteed there's going to be litigation. And the existing plan can't be used, so there have to be interim plans, and that creates all sorts of difficulties and dynamics that tie in with what we were discussing earlier in the prior panel, which is, do you even want this stuff done in the political process? Do you want to have apolitical actors doing it? Federal judges clearly are not supposed to be politicians in the same way that state legislators are, and so we find ourselves really in an extraordinarily complicated dynamic. And it makes you wonder how the Supreme Court will view the very nature of the complications when they come to think about the constitutionality of the act and how to enforce it. We have time for questions now, so I want to give folks an opportunity to ask questions, and within folks will go around microphones.
Thanks. Thanks. Yeah, I wanted to ask probably Nina, but whoever would like to comment, about the recent Supreme Court decisions, potential effect on the arguments about constitutionality or not constitutionality of Section 5 in relation to the fact that it seemed to shift the burden somewhat on the parties in terms of preempting essentially the DC District Court with respect to any potential violations of Section 5 in the current plans. I mean, it sounds as though actually the San Antonio District Court is doing a lot of please you two decide it and don't let us get involved. But if they do actually have to get involved, my understanding is that they have to take the Texas plan, and then you have to say, well, you can't take this and you can't include that and you can't include something else, which does change the burden. And then I wonder if that affects any, is that kind of the beginning of the death 5,000 cuts for Section 5, or do you think that it potentially contribute to it being strengthened or something else?
Yes, and then no. It's not the death. And I think, with respect to Texas voting rights and Texas litigation, it's really the whole story why we need Section 5. I mean, you know, it gets a little complicated with timing sometime, but the truth is that since Texas became covered in 1975, it has had an objection to one or more of its statewide redistricting plans in every single decade, starting with the 1970s. Section 5 remains one of our most important tools to prevent discrimination. And I don't think that the Supreme Court at this point, I don't think there's a majority on the Supreme Court at this point to take that away from us, because it's been so vital and so important. And we have a 2006 decision which found the marks of intentional discrimination in the last round of redistricting. I think we've got a really good case this time on intentional discrimination as well. So I'm not the doom and gloom person on Section 5 that you'll hear a lot of people. I mean, I walked out of the mud argument quite sure that we were not going to have the constitutionality taken away from us of Section 5, and I continue to believe that the Supreme Court is not going to take this statute away from us. Have things become a lot more murky since this decision? When you get into a situation where you have impending primaries, the need for a local court to draw an interim plan, and no preclearance, yes, things are more murky. And we'll just work it out as we go.
I have a question addressing the panel theme of the future of redistricting in light of this wonderful discussion about the Texas case, and I think it could be addressed to all the panel members from their different perspectives. Fortunately, the rest of the country isn't exactly like Texas, but of course, in many ways, it is. We have tremendous Latino demographic growth and increasing Latino political participation in many, many places. And in California, as we've heard, significant Asian American demographic growth as well. We have partisan conflict and incumbency protection as the major political value in the redistricting process, certainly everywhere, as we do in Texas, maybe not quite as extreme. It seems to me the Texas experience has been sort of disastrous for the dominant party in Texas, and kind of a debacle for the state, at least from a good government standpoint. What are the lessons that you would draw from the Texas, ongoing Texas litigation and political redistricting experience for other states which are not exactly like Texas, but have some of the same issues in the future, including in the playing out of this redistricting process in the next few years?
I mean, there's one very easy lesson to draw, and I think that is that many of the legal constraints operate primarily to prevent the most grotesque form of overreaching. That is, I think, if Texas had not overreached quite as much as they had, they would have been able to get preclearance either from the Department of Justice or from the DDC, or if not from the DDC, from the Supreme Court. I think, you know, the numbers Nina put up showed that, you know, Texas, what was it, 80% or 70% of the overall population growth is attributable to growth in the Latino population. Texas got 4 new congressional districts and drew fewer Latino opportunity districts than it had last time around. And so, you know, and so this question of when you just go too far, does the system push you back? I think that's one thing to draw out of this going forward, which is at some point partisanship or incumbency protection becomes so grotesquely dominates the system that the system will find some way of snapping back at that. And that's one lesson I would draw from this is kind of more marginal, incremental, either partisanship or discrimination, frankly, is not going to be picked up nearly as much by the legal process as the most blatant forms.
I'd only add that I think, in line with my thesis, that Section 2 would also cover those extreme cases of discrimination and pushback from the Texas legislature, and that Section 5 is no longer needed to combat those extreme cases of discrimination.
I'd like to answer that because having litigated a Section 2 case from 2001 until 2006, which ended up okay, but took an awful lot out of my life and out of his life and out of his 2 younger siblings' lives, one of whom I had in the middle of all of that. I prefer...
And you've only just met.
I would prefer the burden shifting of Section 5 because hopefully, if it works right, it will block a plan before going into effect. Because yeah, there are small and small institutions that are there to litigate Section 2, but it's overwhelming to do one of these cases. And certainly, I've been feeling really overwhelmed during these past few months. Even with the team that I have, we're all amazing, and with Pam's help, and all these folks who've been working also with other plaintiffs' teams. I prefer the structure of Section 5 and think it's still necessary, at least in the experience we've been having in Texas so far.
I just would add one last thing. I think it's interesting to think why Texas did overreach, and whether they are operating under the assumption that this regime is in fact over, and that they thought they had votes on the court, that at least were not ready to express themselves this time around. Yeah, and I wondered about that myself, since it seemed to me there was necessary reason to reach right then.
Hi, Nina, you mentioned at the end that having more reflective maps might lead to the Latinoization of both political party platforms. What do you hope that will look like?
Well, I hope it would involve less race baiting. That would be a good start. When you look at polling of Latino voters care about a lot of the same things that other voters do: the economy, the state of education. But one thing that is notable is two things. The number of people that the number of Latino voters who personally know somebody who's undocumented right now, who's here without lawful presence, and the number of Latino voters who've said within the past year they've talked about immigration reform either with friends or family or colleagues. And so just to focus in on that issue, which I don't think is being well addressed by the leadership of either political party right now, I would hope that there might be subtle shifts to reflect what Latino voters are thinking about with respect to that.
You're taking the microphones around, so. No, I want you to just take the microphones around.
Go over here. He's got the next question.
So this is a question for Nina, but I guess also for Pam, since you're co-counsel in these cases. So one argument, I grew up in Texas, in Pflugerville actually, so my congressman used to be Lloyd Doggett. I think it's
up the road.
Yeah, now Michael McCall. But one argument I often see thrown out there in Texas in the press is that under proposed redistricting plans, there will no longer be white Democrats. And one response I'm sometimes tempted to have to this, and I was tempted to have seeing your PowerPoint, is, if this ends up being the consequence, it might just be an unfortunate but unavoidable consequence of white Democrats being in a group that's growing demographically more slowly and where the majority of white voters are identified with the other political parties. So it's a similar situation to being an Afro-American Republican. Do you think that's the right response to give, either sort of politically or in terms of the facts on the ground, or do you think there's a way that redistricting in Texas is going to evolve in a way that will ultimately lead to there being white politicians from the Democratic Party in office there?
I think you're exactly right. And I promised myself I wouldn't say more on that subject while the TV is on. So I think you're exactly right.
I'll say something that takes us back one level of abstraction, which is a system that involves single-member districts is going to have the consequence of taking groups that are, and maybe Nick is going to talk about this in his presentation later, but is going to have this sort of consequence when white Democrats are interspersed in overwhelmingly white areas, which are heavily Republican overall. That it's not a function of the fact that it's not that there are no white Democrats. It is a function of the fact that white Democrats do not tend to constitute sufficiently large and geographically compact groups to constitute districts in a place like Texas. If they did, they would be getting districts. That is, if there were a whole lot, if that, there must be some part of the state that there are you know, like Abilene or someplace like that, there were a whole lot of white Democrats living in Abilene, there would be a district electing white Democrats there. And it is a function of the fact that we use single-member districts, that groups that are geographically dispersed in that sense are going to find it harder to elect than groups that aren't. And that's true for white Democrats. It was true for Asian Americans in New York City, where they're 6% of the population, but it's impossible. And it's not that even they live all in integrated communities. Many of them live in heavily Asian American communities, but they're too small and too far apart from each other to connect them. You can't connect Chinatown to Sunnyside, even using Nate's way of they drive over here, drive over there. It's going to be really tough to do it because you're going to have to cross so many districts to get inland. And I think that is a function of the choice to use districts. It's not a function necessarily of how the districts are drawn once you've made that decision.
Okay, I've recovered. You're from Pflugerville, so you're near Austin, and you know there's a lot of white Democrats in Austin. But there, like Pam said, there aren't enough white Democrats in Austin to comprise the district. And so that's why I think it's incredibly dangerous to focus on the incumbent. Oh, there's X number of white Democrats in Congress from Texas. What you have to do is actually look at that district. And if that's a district where whites are controlling the outcome of the primary in such a way that Latino presence or other voter presence in the district is not able to nominate and elect the candidate of choice, then, you know, when somebody else takes a look at that district, in this case, the leadership of the Texas House and Senate, they may not see that as a valuable thing to preserve.
I want to just jump in on that last point, because I think this goes to what you've been saying, Nina, about to what extent we should view it through party versus race, which is, and you're absolutely right that you look at Lloyd Doggett and that the parties definitely want to protect their incumbents. But as you get fewer and fewer of those incumbents there, and you only have 12 white Democrats in Congress in the South, for example, and you have 2 that are in Texas, and this is in the congressional delegation. And so Lloyd Doggett is terminally hidden. I mean, when his district flips, it'll, like, depending on how they will, when he resigns, he'll go the way a lot of the other Southern white Democrats do. And then, as the personnel really does look more highly correlated between race and party, then you get a sort of different dynamic than the one that you're suggesting. Now, I think you're absolutely right that Latinos have greater power when they can operate as the critical sort of group that both parties can court. But what do you see as the future in Texas? I mean, because it seems like, you know, it's going not directly the way of California, but it's getting closer and closer to it. And then that's part of a larger question, which is, do you think 10 years from now you'll be making similar arguments about the percentages in the population of these districts that you would want, particularly 50% CVAC districts? Do you think that, sort of extrapolating out from that, do you think that the same sort of districting arrangements that you're pushing for this time will be ones that, given what you know about Texas, you'll be asking for in 10 years?
Well, as to the first point, I work for Latino voters, and I try my best to achieve whatever the result is that enables them to achieve their goal, which is to nominate and elect their candidate of choice. I don't make judgments about who should represent Latino voters. If Latino voters want to nominate and elect a person who is purple with green spots, who, you know, somebody who's African American, somebody who's Latino, somebody who's Anglo, it's their choice, and that's the perspective that I view it from. As to what districts, you know, what the numerical cutoff is for different districts, we use a pretty functional analysis. We have lots of election data available to us in Texas, and we do want to strive towards districts that enable Latinos to nominate and elect their candidate of choice, you know, and there's typically not kind of a bright line test for that, although we know we have to fulfill the requirements under Section 2.
Yeah, I didn't mean to want you to put your political scientist hat on more than the lawyer hat, which is to say, just what, because you're there, in California, we'd be making different arguments maybe about, and again, it depends on which part of California. We're talking about Central Valley, we're talking about San Francisco, we're talking about LA. What do you see as the trend? Maybe the answer, because of the partisan realignment in Texas, is that actually things are getting worse, not necessarily better, in the sense of what percentages are necessary in order for Latinos to elect their candidates of choice. Or maybe they're getting better because you think that over time that they can rely on greater crossover voting in the areas where they're not concentration.
If I can just jump in for a sec here, it seems to me that one of the fundamental differences between California and Texas, which your question kind of alludes to, is in Texas you are moving in some very important ways towards a system right now in which there is a white political party and there is a non-white political party in Texas. That's not the case in California at all. That is, the Democratic Party in Texas is a multiracial, multi-ethnic party. The Republicans, in part because they guessed so badly at the Prop 187 phase, is becoming, it remains an overwhelmingly white political party. What's complicated in Texas is the last round of redistricting. I don't think anybody said anything overtly this time around, but the last time around, one of the Republican members of the legislature said, you know, they were hoping to create a system in which white people looked at the political system and thought there's a party for white people and there's a party that's not for white people. And so those two dynamics are very different in the two states in terms of partisan realignment and like, and that probably has its own set of effects.
But that's sort of in tension with what you're saying, right?
Yeah, I mean, I really think that whether or not there's political diversity in the Latino community in Texas is largely up to the Republican Party right now. I think if the Republican Party gets its act together and starts reaching out to the largest growing demographic of their state, which many Republicans believe that there are a lot of Latinos who can vote Republican because they see an alignment with certain positions of the Republican Party. I think that Texas is at a tipping point in terms of what political parties are going to do with all of these Latinos. You know, are Democrats going to continue to fracture to preserve the last shreds of, you know, incumbents who may not be preferred candidates of Latinos? Are Republicans going to start knocking on doors and saying, I believe in comprehensive immigration reform, or some Republican version of comprehensive immigration reform? So I don't think that we're going to split up, or maybe there isn't just one future here of splitting into a party of brown and a party of white. That's like, it's like, you know, the Christmas Carol, right? You know, people are either going to be weeping, you know, not the singing one, the movie one, the story one. You know, there's
you mean the Ghost of Christmas Future?
Yes,
oh, okay. I was thinking like, you know, Silent Night. God rest you, Mary Jo.
I'm looking for you to help me. Yeah, I can't talk as well as Pam can, but that's what I'm trying to say. I mean, either the Republican Party is going to be weeping over its own grave because they could not reach out to Latino voters, and this horrible scenario comes out where you have a party of one race and a party of another, which is pernicious. Or we're going to see more people reaching out and doing what they need to do to have a healthy political system in Texas.
I just want to make a quick comment because I think California is instructive in the sense that that's exactly what happened in California. The Republican Party was incapable of changing its rhetoric, and I guess I have to respectfully disagree. It is a party of whites. If you looked at that last slide I had about party
that's exactly what I was saying, is that the Democratic Party in California was not a single race party. The Republican Party was.
The Republican Party is now,
that's right.
because they chose not to incorporate Latino, and they haven't been incapable of incorporating Latino issues. And so I think, you know, Texas may be going the way that California did in the 90s, in the sense that at that point Latinos were about 35% Republican, and that shifted completely, and among Asian Americans too, because of the policies that the party pursued and their inability to even change those policies.
Yeah, my point was just that the minority groups in California are part of a multiracial party, not that both of the parties are multiracial.
Yes, and we have the precise same problem of the Democrats not wanting to incorporate Latino representation into their districts in the same place. And yeah, and term limits, ironically, kind of fix that. But you know, otherwise, we would be in the exact same position of having to litigate.
I was wondering if the panel could address the bailout provision related to Section 5, and whether you think, if we assume that maybe the Voting Rights Act, or Section 5 at least, is somewhat in trouble from a constitutional perspective, if you think that the court would be willing to use the bailout provision as sort of a saving construction, as changing some of those requirements for a subdivision to bail out in order to kind of constitutionally save the Voting Rights Act, or Section 5 at least, and whether that would actually kind of harm maybe the deterrence, the positive deterrence effects if we somehow broaden the requirements to bail out.
I think bailout is almost a farcical remedy in that what Justice Thomas cited in Northwest Austin, 17 jurisdictions had received bailout, all of them in Virginia, all of them represented by the same civil rights attorney that sought bailout. And even, does anybody know how Northwest Austin ended? Did they receive bailout? I know it was hotly contested. They were bailed out eventually. But I don't see bailout as the long-term solution to the constraints that Section 5 places on jurisdictions. It's almost always heavily contested with every jurisdiction, and it's almost never available.
I guess I see that differently. I mean, I think one of the difficult questions is why jurisdictions don't bail out. I think it is understood that many jurisdictions actually are eligible to bail out and choose not to. And it's this difficult narrative, because on the one hand, the statute is so burdensome and on all the language Joshua quoted, and yet at the same time, there are jurisdictions that seem to be going merrily along, not taking advantage of it. And I think it's a curious thing. My prediction is that the court will see the numbers that have increased, but not increased enough to think that it's become more calibrated. I would urge the court to think about it more as, there's a reason they're not bailing out, because they actually find it to be useful. I know that there are several justices who voice views that say, no, it's, they're cowards. I'm not sure what to make of that language, because I actually think it's denying locals a decision to say, you know what, the system works for us, it's not burdensome, we could bail out, we choose not to. And as long as it's there, I think from a doctrinal point of view, it's critical in terms of saying, well, you know what, this burden is there, clean up your record, go negotiate, and get out if you want, and if you don't, that might get back to Pam's point, is who's going to decide this? Maybe let the jurisdictions decide for themselves.
These guys on my left preempted a lot of what I was going to ask. That's okay. Given that the Democratic Party in California is using percentages, and the Republican Party is using percentages, and the independents are increasing, and I remember that was due somewhat more largely to Latinos becoming independents. Independents have no political voice in California. And so my question is, do you see a way, if that's an accurate hypothesis or scenario, a way for Latinos to achieve significant political voice if independents have really no voice at all?
Well, we're talking about a single-member district election system when we talk about redistricting. And so, the question isn't really about whether you have a statewide voice or how you might express your statewide voice. I think the question in redistricting is, how are the district lines going to be drawn so that people can come together, and whether voters are going to act as swing voters between Democrat and Republican candidates, or whether they'll mount their own candidate. I don't know, but I think the question is much more limited than that when you're in single-member districts.
I mean, this may be something, well, Nate just left Elvis has just left the building, so he's not here to answer this question, but perhaps if you can answer it, which is, lots of people are independents, but their actual voting behavior is quite predictable anyway. That is, they don't register with a political party, but in partisan elections, they always vote for the Republican or they always vote for the Democrat, in which case their position is going to be effectively the same as any other voters.
We call them leaners.
Yeah.
So the follow-up question is, do you lean to one party? Do you identify with the party? And the second question is, do you lean to one party? You have leaners. We do have a growing number of pure independents that don't lean.
Yeah, so the question is, with the top two primaries, is that going to sort of solve itself by they'll be participating in those primaries? And if they actually are both independent and they share a point of view as opposed to just being fractured across a variety of dimensions.
Right, and one would think it's speaking to the point, part of the reason is because neither party is speaking to the interests of those groups. So one would think if either party were to change positions so that in fact they are incorporating issues that perhaps those voters feel aren't part of the political discussion, then that would change, right? So we know very little about what independence means to different people, but I think among especially immigrant groups, it's really a reflection of the fact that what neither party has really been dealing with things that are most important.
This is a question for Nina as well. So you mentioned a couple of times some of the language in LULAC about discriminatory intent, but I was curious what you thought about the rest of the decision. In particular, all the abundant language in Justice Kennedy's opinion about how if you're combining two culturally or socioeconomically separate groups in a district, that district no longer counts as a valid remedial district under the VRA. And so you showed us charts and graphs with data on the racial composition of various districts. But I was curious if you look, not only at the Latino CVAP numbers, but also the degree of socioeconomic, cultural, income similarity among Hispanic voters in different districts, or are you basically neglecting that side of the map in your work going forward?
When we do litigation under Section 2 and we're proposing a district, especially a district that might be new, we have lots of lay testimony. In addition to demographers who might talk about similarities from a more quantitative point of view, we do have lay witnesses, and I think it's a very good idea to bring in lay witnesses from different parts of the district to talk about similarities or differences or what it's really like on the ground, whether there's a particular mall over here that folks over there go to. I think that's tremendously important to give the court a rich sense of what it is that you're proposing to put there. As to LULAC versus Perry, I'm very much in the same point of view as Pam with respect to some of that language. You kind of had to be there with respect to that case and sort of understand what was going on in terms of being able to find a violation over here and what that meant about the Southern District over there, and the fact that nobody was defending that strip district. No party was defending it, so nobody did put on evidence about whether or not people at one end and the other end had anything in common.
We have time for one more question.
Over here. So I had a question for the panel broadly. I read a student note in the Yale Law Journal earlier this month about comparing the fallout from the fight to integrate schools to the fight to have voting districts that are representative of racial minorities, and part of the backlash from the fight for school integration is you have these school decrees that allow schools to get out, kind of with the ballot provision, you get out of the court supervision, and then the schools just go back to being even more segregated than they were before. And so my question is centered towards this idea of, if we get rid of the Voting Rights Act, if we get rid of Section 5, and we have this history of seeing what's happened in our schools, are we worried that the same thing's going to happen if we get rid of Section 5? And for Josh in particular, going back to the analogy that Pam made earlier today, if we're interested in deterrence, if we're interested in keeping people from committing murder, what is the life without parole equivalent? Something that will have substantial deterrent effects for these harms that you acknowledge still exist in parts of the South and in other parts of the country. So I don't think there's have responses to those two questions.
Yeah, it's undisputable. It's indisputable that there is some deterrent effect from Section 5, and that Section 5 may prevent some. And I agree with Professor Katz that a lot of jurisdictions probably take comfort in Section 5 that they know they can get something pre-cleared without having a big political dispute. But Section 5 was and remains an extreme remedy that completely distorts the constitutional process of our government. And that extreme remedy can only be justified under extreme circumstances, and only was justified under extreme circumstances. So I'm not as pessimistic about the state of racial affairs in America to think that with 40% of Southern legislatures being African American, or the presence of legal groups representing African American rights or Latino American rights, that we can reasonably believe that we will return to a system of Jim Crow, Section 5, we're out of place. Therefore, I don't think that the extreme remedy that is Section 5 can be constitutionally justified. As I think Justice Roberts said in Northwest Austin in his majority opinion, or I guess his unanimous opinion, the remedy that is Section 5 must be justified by current political or current data, and that simply he was skeptical of whether that was there. I affirmatively say it's not there, that data was only present possibly in '82, but it is not justified by the record that Congress assembled in 2006.
I guess I think two things would happen, maybe certainly more actually. The African American faces that you see in southern legislatures would likely disappear because they're from majority minority districts in lots of places, and it's the Voting Rights Act that's keeping that there. Nina made reference to the racially polarized voting, and one of the differences you do see in covered and non-covered jurisdictions is that it's more polarized in the covered jurisdictions than the non-covered, and I think that's going to play out more effectively without Section 5 in place to be a guard against that. And I guess the sort of fallback that, well, Section 2 could take care of it if Nina has just more strength than any human on earth and can keep fighting these cases. I worry that when Section 5 goes down, it goes down doctrinally with an analysis that I think applies onto Section 2. It's the next one on the chopping block, and it seems very easy to make the claim. You don't have the regional differences, but I can write that brief. I mean, I know what it looks like, that argument. So, you know, it's not an end there. So I do think, you know, we'll see a difference. The school analogy is a fascinating one, and I think one of the things that's actually quite interesting about the school analogy is not just the schools getting out of the desegregation decrees, but actually the schools that fought dissolution, and there are some of them that did. Kansas City, Detroit did it, and it's an interesting analogy to bail out. Why aren't they pushing out? Because they actually like the supervision, and it does certain things that are useful for them, and I think that's looked at with skepticism, and it ought not to be, that there's a reason that localities will embrace federal regulation that are actually positive and good and I'll say empowering to them. So,
I mean, this takes us back to kind of where this panel began, and so maybe it's a good place for the panel to end, which is, do I think that if the Section 5 were struck down, that the entire gains of the Second Reconstruction would be rolled back? No, I don't think so. I think some of those gains are cemented into place and are enduring, and the American consensus on the right to vote has changed into powerful ones. Do I think there will be lots and lots of low-level discrimination that is stopped by Section 5 that will occur? Yes, and this goes beyond the panels here, which have been about congressional redistricting and state legislative redistricting. People watch that stuff carefully. But what Section 5 also does is it prevents changes in polling places in local elections. I had a case in Arkansas, which is not a covered jurisdiction, where they moved the polling place in the largest black precinct 10 times in 3 years, several times outside of the district. Will there be more restrictive registration practices? Yes. Will states come up with restrictions on absentee ballots? Yes. Will there be more voter ID laws? Yes. Will there be a lot of redrawing of annexations and de-annexations of areas of municipal elections? Yeah, I think all of that stuff is far more likely to happen in a world where Section 5 doesn't exist than in a world in which it does, and that will require and put a huge burden on the very few lawyers who do voting rights work, among whom I hope to see many of you all in the future. So we'll take a break here and come back for the last 5 minutes? 10 minutes.